Yes, Miss Gumble.
Please, your lordships and my lady. In this case, I appear for the appellants, together with my learned friend Mr. Sheldon, and my learned friend Mr. Porter, together with Miss Mason Tom, appear for the defendant.
Well, it's very good to see you all. We've read the papers in this tragic case in great detail, so we think we're on top of the issues. I hope we are. We wondered whether you, I'm looking at the distinguished row in front of us, have you had a chance to discuss how you're going to divide up your time today?
We haven't with the defendant's team, but between myself and Mr. Sheldon, we've hoped that we would certainly be finished by lunchtime.
Yes.
Mr. Sheldon will address the contributory negligence issues for ground 4. I'm hoping to finish by around 12, and then for him to deal with contributory negligence and the defendants to have the afternoon.
Yes, so you're dealing with grounds 1 to 3, and he's dealing, Mr. Sheldon's dealing with 4. I wonder whether contrib's going to take a full hour. No, I don't think so. So it sounds like Mr. Porter may be on his feet before lunch.
Yes.
Well, that should.
We won't be long between us.
No. Right. Well, thank you. That's good. Are the claimants or any of the claimants in court?
My lord, yes. Sitting immediately behind me is the first claimant, the wife of the deceased.
Whatever the outcome of this appeal, all of us would like to express our deep condolences and to the family, and we appreciate the suffering and how long this litigation has gone on, whatever the outcome of it is, and I can assure you we're going to give it our very most serious attention.
Thank you, my lord. My lord, I hope that will help with the timing that I've handed in 1 page of what I've called the map, just so your lordships can see I'm keeping to my timetable, as it were.
Thank you.
My lord,
So we've read it. We've read. You can take it that we've read the key documents, and some of the authorities, obviously, some of us are more familiar with some of these authorities than others. But you can, I think you can rest assured we think we're pretty much on top of the issues. If that's
thank
any
you,
help.
my lord. That's very helpful. I'll only be going briefly to the authorities on material contribution. I think are the only ones that I will
Yes.
refer to,
Yeah.
because that is a separate issue which only occurs if we don't succeed, in a sense, if we don't succeed on the first issue, but it
Yes.
is a more directly a appeal on grounds of a mistake in the legal application, whereas the first ground is more of logic. If I was just going to, I know the court has all read the papers, but if I can just summarise very briefly the position. Mr. John Jones QC died in April 2016. He'd been a patient of the defendant since February 2016, referred to him by his GP in February 2016, and had been an inpatient in the Nightingale Hospital since March 2016. And he was admitted by the defendant after the deceased mother had emailed the defendant via his PA, and all communications were via PA, that our son John Jones is in urgent need of attention. I believe he is a danger to himself at this point, must be provided with a safe space. So that was the basis on which the defendant arranged the admission. The defendant, in fact, denied that he was the admitting consultant, and much of the cross-examination focused on that. He had been asked in a request for further information as to whether he was, what the treatment plan, and his answer had been that it was the second and third defendants who were responsible for the treatment plan. spotting cross-examination, eventually admitted that he was the admitting consultant, and that is important. A finding of the judge unsatisfied that Dr. Pereira was in breach of duty by not communicating to Mr. Jones he wouldn't be available for the next 3 weeks, and there was a negligent failure to give a sufficient handover to Dr. Bakshi. He had said, see Dr. Bakshi for what the treatment plan was, but we say eventually he accepted in evidence that he envisaged appropriate therapy being an important part of Mr. Jones's effective inpatient treatment. He was reminded in cross-examination of his evidence at the inquest that a psychological intervention could have made a huge difference, and I would probably said in terms, I would probably, with the benefit of hindsight, have insisted that he engaged with therapy on day one, giving him the opportunity. So as far as the defendant was concerned, psychotherapy was always an important part of the treatment plan, and the failure of the handover, we say, must be connected to the failure to give a treatment plan, and the fact that he denied being the admitting consultant is important for that purpose. The judge accepted the evidence of the claimant's expert that therapy was the cornerstone of the treatment plan for the deceased, and the judge found, nevertheless, it's clear from all the documentary evidence that Dr. Pereira was the admitting consultant. In all evidence, he thought to qualify that by being for Bupa purposes, but that seems to me a defensive view. So the judge failed to take into account that this meant he was responsible for the treatment that was initiated when he became an inpatient. And at paragraph 192, the judge found, I cannot find Dr. Pereira liable for any omissions in the treatment which Mr. Jones received until his return, whilst the lack of a handover to Dr. Bakshi may have contributed to any admissions by her. I've not tried the question of whether there were any admissions by her. There are a number of difficulties with that contention because, of course, the treatment plan, if he was the admitting consultant, which the judge found he was, he should have been responsible for the treatment plan. And it didn't matter whether there were, as was received from a later paragraph 224, it didn't matter whether Dr. Bakshi's treatment was negligent or not. What was important was that the treatment plan and the treatment included psychotherapy, and that was a matter for which the judge should have found he was responsible. It also goes to material contribution, that it is relevant that there was a material contribution to the lack of treatment for his declining condition. Whether or not Dr. Bakshi was negligent is irrelevant to whether there can be a material contribution, and one of the issues is whether the judge correctly understood that there can be a material contribution where there is an underlying deterioration in condition rather than only where there is somebody else who is negligent. So we do criticise that analysis.
Well, Ms. Gumbel, can you just help me? There are 3 specific breaches of duty found.
Yes.
And there's no challenge other than those
Indeed.
3. So you've got the failure to inform the deceased that Dr. Pereira was going to be away for 3
Yes.
weeks. There's the failure to give an adequate handover.
Yes.
And then the failure then picks up effectively on the 11th of April
Yes.
when Dr. Pereira sees the deceased
Yes.
again. For myself, no doubt the fault is mine. I have difficulty working into those specific breaches of duty, the failure to give a treatment plan. As the admitting consultant, there's no other challenge.
The failure to give the treatment plan is because he denied he was the admitting consultant.
Yes, but they got over that, if I may say so. All credit to Mr. Sheldon for a focused, and one might say dogged cross-examination. I mean that as a compliment, not in any pejorative way. But he wasn't giving up, and eventually the admission came that he was the admitting
Indeed.
doctor. But there is no breach found by the judge about a treatment plan.
No, but the difficulty the judge had in linking the lack of treatment to the breaches was that he found and thought it was very important that the diagnosis wasn't negligently wrong, the bipolar diagnosis, and did find at paragraph 224, if the defendant had made an admission on the basis of a trauma, then the treatment that followed would have included psychotherapy. So the basis of admission, which we say must include the treatment plan, is the only aspect that the judge found wasn't made out in order to find that the treatment wasn't the treatment that he should have got. And the importance of that is that Dr. Pereira himself said psychotherapy should have been part of the treatment.
So you're focusing on the fact that he was the admitting clinician and denied it initially, or not admitted.
Indeed.
Are you saying that in some way that aspect of the evidence, as accepted by the judge, aggravated the breach of duty that he found in a way which is relevant to his decision or the decision on causation?
Well, it led to the admission that there should have been a treatment plan which included psychotherapy, and the fact that he didn't accept he was the admitting consultant and therefore didn't accept he was responsible for the treatment plan, and yet accepted that there should have been psychotherapy from day one, means it's highly relevant that he denied he was the admitting consultant, and the judge's finding that he was should have led to the finding that the treatment plan should have included psychotherapy, because that was the defendant's own admission. The defendant admitted that psychotherapy should have been part of the treatment plan, but didn't admit that he was responsible for the treatment plan.
And how does this, and I'm sure it's me being slow, forgive me, Miss Campbell, how does this then affect the issue of whether the breach he found, breaches he found, but particularly the breach on handover, did not was not a causation factor?
Because if one looks at paragraph 224, which is paragraph where he deals with the causation, the trail on causation, at paragraph 224,
So that's page 80,
87, yes.
Yeah. Right.
The only
This is, I know, this begins, if contrary to my conclusions above.
that is the conclusion that the breach of duty didn't lead to him finding causation. If it had provided a post-traumatic diagnostic formulation, as described by Dr. Meehan, and would have done so before Mr. Jones' admission to hospital, then my view of causation would be different in the following ways. On that hypothesis, Mr. Jones would have been admitted for treatment for a condition resembling, though not the same, as PTSD. So we say the basis of the admission, which must include the treatment plan, is crucial in this scenario. And the judge goes on to find, as to the correct treatment of such a condition, Dr. Meehan said Mr. Jones required the lifetime of supporting and assertive therapeutic engagement. Formal psychological therapy is a deeper form of therapeutic engagement. I did not detect a significant disagreement between the expert witnesses about the appropriate treatment of such a case with psychotherapy. But of course, what Dr. Pereira has accepted is that he should have arranged the psychotherapy from day one, but his case had been he wasn't the admitting doctor.
Is that strictly correct? He admitted with hindsight that from day one, psychotherapy would have been advised. But you have the finding by the judge, which isn't challenged, at paragraph 191. At the point when it was agreed that Mr. Jones should be admitted, I'm not satisfied that Dr. Pereira had a real opportunity to work on preparing a treatment plan for him as an inpatient, or to discuss with him the question of whether or not he would participate in the group therapy program. Nor do I consider he was in a position to make any assumptions or predictions about that participation. And then we have this. The reality was that Dr. Bakshi would take over Mr. Jones's care once he'd been admitted. Now, those were the findings the judge made. He just didn't have the time, because the request for admission came from Mr. Jones's parents.
Yes.
Dr. Pereira had seen Mr. Jones on 3 occasions. But when it came to the actual treatment plan following admission, he just wasn't there. It was Dr. Bakshi who was taking over.
But that doesn't sit with paragraph 224, that if he had admitted him with a different diagnosis, then the treatment would have followed, would have been psychotherapy. And we say there's no basis of making the distinction between an admission for PTSD and an admission for bipolar, that the treatment plan wouldn't follow with psychotherapy, because the defendant himself accepts that psychotherapy should have been part of the treatment plan, even with his diagnosis of bipolar. That's why there is no logic in making the finding that only because the differential diagnosis was different did the treatment not follow with psychotherapy. And the emphasis the judge placed on the differential diagnosis of bipolar being not Bourne negligent is misconceived, because even with the diagnosis of bipolar, if the treatment plan should have included psychotherapy, which the defendant himself accepts it should, then on admission with proper information to Dr. Bakshi as to what the condition of the patient was, the findings at 2, 3, 4 and 5 in paragraph 224 would have followed. There is, we say, a flaw in the jump from, because of the differential diagnosis being bipolar, he didn't get the treatment, when really the reason he didn't get the treatment was that Dr. Pereira didn't conduct a proper handover and discussion with Dr. Bakshi, which on his own case would have included the claimant getting psychotherapy. And then from that, subparagraphs 2, 3, 4, 5, 6, 7 and 8 would follow.
But the patient was assessed the next day, that is the 23rd of March, by Dr. Camp. And
Yes.
clearly part of that assessment was psychotherapy. And what the patient then expressed on that day and on the 29th was that he was seeking one-to-one psychotherapy.
Yes.
So is a reasonable inference to be drawn that as part of the handover, there was a discussion between Dr. Pereira and Dr. Bakshi about certainly a need for psychotherapy?
Well, it was never said that there was, and had there been, then it should have, then the judge's finding that it was the diagnosis of bipolar was the only reason he didn't, because from paragraph 224, the implication is that it's the diagnosis of bipolar is the only reason that he didn't get psychotherapy. And there's no basis for the judge to find that, because Dr. Pereira himself doesn't say, I didn't think psychotherapy was appropriate because I'd made a perfectly legitimate diagnosis of bipolar. He says the contrary. He says that psychotherapy should have been the mainstay of the treatment. So it makes no sense to find that the only reason causation hasn't been proved is because the admission on a diagnosis of bipolar wasn't negligent.
Is that the only reason causation wasn't?
Well, it is from paragraph, if one follows through paragraph 224.
Well, you took us back to, forgive me, back to, if I may, back to paragraph 191 and 192 as part of your run-up to 224. And you may be coming to this, and if you are,
Yes.
please don't let me take you out of your running order. But at some point, for my part, I would be interested to know where you say the judge was wrong in what he said, wrong in a way that we could interfere with, in what he said in paragraph 191 and 192.
Because for the very reason that they are inconsistent and illogical when seen beside paragraph 224, because on the paragraph 224 hypothesis, there is, just by admission with a post-traumatic diagnostic formulation, it would have followed that he would have got psychotherapy. And we say there is a flaw in that logic, because it isn't the diagnosis of bipolar that stopped him getting psychotherapy. Therefore, paragraphs 191 and 192 do not sit with paragraph 224, because if the only reason he didn't get psychotherapy was the bipolar diagnosis, then why would he have got it, and why would causation have been proved if he had given a diagnostic formulation of post-traumatic diagnosis?
What do you say to the number of propositions in 191 and 192, and I'm not clear which of them you accept and which of them you challenge. So first of all, there's the assertion, first sentence, judge wasn't satisfied that Dr. Pereira had a real opportunity to work on a plan. Secondly, he didn't find that he was in a position to make any assumptions or predictions about his participation. Thirdly, the reality was that Dr. Bakshi would take over Mr. Jones's care once admitted, and therefore he couldn't find Dr. Pereira liable for any omissions prior to return. And fifthly, although the handover may have contributed to any omissions by her, he hadn't tried the questions whether there were any omissions. So which of those propositions, which seem to me at the moment to be part of the judge's reasoning, which of those do you challenge?
We challenge that the time to make a care and treatment plan, that he didn't have time to make a care and treatment plan. His case was he wasn't responsible for the treatment plan at all. And we say once the judges found he was the admitting doctor and there was a flawed handover and he didn't give a proper handover to Dr. Bakshi, then that doesn't sit with he didn't have time to make a treatment plan. His case was he didn't make a treatment plan at all because he wasn't the treating doctor. And what the judges also found is simply by making a different diagnosis on admission, he would have got whatever doctor, he didn't need to find any admissions in relation to Dr. Bakshi in paragraph 224 to find that with admission on a diagnosis that involved psychotherapy, he would then have got psychotherapy.
But that's what he was assessed for the next day by Dr. Camp.
But that isn't the reason the judge found that had only if the diagnosis had been different, causation would have been proved. That's the effect of paragraph 224, is that the only reason that causation couldn't be proved is that it wasn't negligent to make a working diagnosis of bipolar. And we say that's flawed because bipolar also included psychotherapy, as the defendant agreed, and therefore it's wrong, the judge was wrong to find that the reason he couldn't find causation proved was that the diagnostic formulation wasn't negligently wrong, even though it was wrong. And all you've got to change is the basis of admission for causation to be proved. And that just doesn't sit with paragraph 191 and 192, because the timing would be exactly the same if the formulation had been a traumatic event. And if he described what he'd known in detail to Dr. Bakshi, she would have known that trauma in the past was part of what he'd learnt from the patient. So what we say is the flaw is that in paragraph 224, just to say that the diagnostic formulation is the only reason that causation can't be proved must be wrong, because...
Can we go back to 192? I'm sorry to labour this point, but it looks to me as though a key part in the judge's analysis on causation was that there was a gap, as he says in 192. He hadn't tried the questions of whether there were any omissions by Dr. Bakshi because the way the litigation had fallen out. And so consequently, didn't that create a gap in the causation? Whatever,
Well,
even if Dr. Pereira, there was an omission in the handover, he was unable to, because he hadn't tried what Dr. Bakshi had done, he was unable to make a finding as to causation.
but if one reads into 224 that he was admitted with a diagnosis of trauma, then the gap doesn't matter. And we say that is illogical for the judge to find the only reason he didn't get the... In 224, there's nothing to say that it wouldn't have been Dr. Pereira's liability, because he goes on to find that on that hypothesis, he would have found for the claimant. The only thing that had to be different was the diagnosis for him to have found for the claimant. That's apparent from paragraph 225, where he says, because that conclusion caused distress to the family, I wish to emphasise the nature of the balance of probabilities test. Judge cannot gaze into a crystal ball and know what would have happened. If Dr. Pereira had approached the case in the ways recommended by Dr. Meehan, there was a chance Mr. Jones would not have died. Measuring that chance is subject to all the uncertainties inherent in diagnosing psychiatric illness and the successful failure of psychological treatment, but I have assessed the chances exceeding 50%. So the only thing that stopped the claimant succeeding was that the diagnostic formulation wasn't negligent, as is the natural reading of paragraphs 224 and 225 taken together. And then if you unravel, was the judge right to find that the non-negligent wrong diagnosis excused Dr. Pereira from any negligence overall, when the logic is, if admitted with a diagnosis that included a trauma, he would have got the treatment. And that there's nothing in paragraphs 224 and 225 to say it still wouldn't have been Dr. Pereira's fault. He's saying I would have found for the claimant if I'd found the diagnosis was negligent.
But that was the evidence. I mean, the judge was very clear. He preferred the evidence of Dr. Meehan to the defendant's expert.
Yes.
And Dr. Meehan was specifically asked whether the bipolar diagnosis was negligent.
Yes.
And he said, in essence, I'm paraphrasing, I wouldn't have made the diagnosis, but I cannot say it was unreasonable. That's what he said.
Yes.
So, in other words, it wasn't negligent.
Indeed.
Well, if we then have the expert whose evidence is preferred by the judge saying this was a non-negligent diagnosis, where do we go from there?
That even though it was a non-negligent diagnosis, it was a diagnosis which, on all the other evidence, including the defendant's own evidence, included the need for psychotherapy. Therefore, there is a flaw in the analysis in paragraph 224 that the only reason he didn't get psychotherapy was because he could legitimately have given a differential diagnosis of bipolar. The differential diagnosis of bipolar cannot reasonably be the reason he didn't get psychotherapy, because nobody suggests that the diagnosis of bipolar means you don't need psychotherapy. And yet the judge seems to have jumped from the diagnosis wasn't negligent to that's the reason he didn't get psychotherapy. And yet it isn't the reason he didn't get psychotherapy. The reason he didn't get psychotherapy was there wasn't a proper handover in which the history, including the traumatic aspect, was explained. So that if the judge seems to think if you have just the diagnosis of bipolar, then you won't get psychotherapy, but you would otherwise. The other flaw in that argument is that the judge found that Dr. Pereira was negligent in not arranging psychotherapy when he returned, and yet still the diagnosis was bipolar. But it's then negligent not to arrange psychotherapy, and yet it isn't negligent that there wasn't psychotherapy from the outset, the only reason being that the diagnosis of bipolar, not a traumatic diagnosis. So what we say is that paragraph 224 simply does not fit with paragraphs 191 and 192. They can't both be right. And therefore there's a flaw
Which
in
do you say is right? You're saying either 191 or 192 are right, or 224 is right. Which do you say is
what
right?
we say. The analysis in 224 is right, except that the even admission with a differential diagnosis of bipolar should, and being admitted for treatment, should have led to the correct treatment, which was psychological therapy.
So I go back to my question. Then, if you're saying the two, I think you're saying that the analysis in 224 demonstrates that the conclusions in 191 and 192 are flawed.
Yes.
Which of the propositions in 191 and 192 do you say are invalidated by the analysis in 224?
that in 191 it suggested that he needed an opportunity to work on the care and treatment plan, whereas in 224 he's saying it's just the basis of the admission which leads to the right treatment being obtained, and therefore it can't be right to say the reason that he didn't get psychotherapy was not the fault of the defendant. It was the fault of the defendant because he didn't hand over with all the details that he should have done of the deceased's condition, which should have led to him getting psychotherapy. And it didn't matter, he didn't need to find any omissions from anybody else. All he needed was for the handover to be on the basis that included a need for psychotherapy, which he himself accepts would have been the treatment that there should have been.
Does the judge find that an admission on the basis of bipolar should have led to a treatment plan involving psychotherapy from the outset?
Well, he finds, what he doesn't find is the diagnosis of bipolar meant that there wasn't a need for psychotherapy.
No, that wasn't the question. We can see in 224 that the judge accepts that a diagnosis of PTSD or something similar would have led to a treatment, an admission on the basis of a treatment plan under which psychological therapy would have been a key part of a treatment plan from at least 22nd of March, which is the day when he's admitted as an inpatient. Does the judge find that an admission on the 22nd March as someone suffering from bipolar should have led to the same treatment plan involving psychotherapy from the outset?
Well, he finds that psychotherapy should have been, he quotes and approves what Dr. Meehan has said, that psychotherapy was the cornerstone of treatment, and accepts that Dr. Pereira himself has said psychotherapy was an important part of the treatment. And it's Dr. Pereira who's made the diagnosis of bipolar and is saying psychotherapy should have been started. And he always envisaged psychotherapy. And when Dr. Pereira came back, the judges found there's a breach of duty in not arranging psychotherapy, even though the diagnosis is still bipolar and is still non-negligently bipolar. But at that stage, Dr. Pereira is negligent in not arranging psychotherapy. So it's implicit that the judge accepted that psychotherapy was necessary even with a differential diagnosis of bipolar, because otherwise, why was the defendant negligent in not arranging psychotherapy when he returned with the same diagnosis?
Well, the respondents say that things were different then. There'd been 4 weeks of admission as an inpatient, which had not worked.
But
it seems to me to be difficult to say it's implicit that the judge accepted there should have been psychotherapy from the outset if he doesn't say so expressly. And I don't think he does say so expressly, does he?
well, he says that he accepts the expert evidence that psychotherapy should
Where's that? Where do we find that?
in relation.
Do you pick it up at 84 or is it somewhere else?
I'm sorry, my lady.
Do you pick it up at paragraph 84 or is it somewhere else?
Yes, that's certainly where the judge finds that Dr. Pereira accepted in evidence he envisaged appropriate therapy being an important part of his inpatient treatment.
So that's the start, and then going on to the question that my lord was just reading. Where do we go then?
Well, he then find the finding that he then at paragraph 125 refers to Dr. Meehan's breach of duty before Mr. Jones was admitted to discuss with him the benefits and role of therapy, the cornerstone of any treatment plan. And Dr. Pereira's acceptance that therapy should have insisted on psychotherapy from the outset.
One, 2, 5 is a discussion of other negligent acts suggested by Dr. Meehan. The judge doesn't find those examples of negligence made out, does he?
Well, no, but that goes to the point as to whether psychotherapy would be the right treatment even with bipolar. Because Dr. Pereira, who made the diagnosis of bipolar, he's there reporting that Dr. Pereira accepted that psychotherapy was a necessary part of the treatment, even with his own diagnosis.
Well,
So that's the
at
important.
1, 2, 5, the judge says Dr. Meehan agreed with Dr. Pereira's evidence at the inquest, but that's with the benefit of hindsight. I would probably, with the benefit of hindsight, insisted that he engage with therapy on day 1. So that doesn't take you anywhere, because hindsight doesn't tell you what should have been done at the outset.
Well,
and as I read 1, 2, 5, and indeed various other paragraphs here, the judge is examining and rejecting other accusations of negligence which Dr. Meehan had given evidence about. So
but
I come back to you've said on several occasions that Dr. Pereira accepted that there should have been therapy from the outset or something along those lines, but I don't myself see that in the judgment.
well, the judge is there reporting that Dr. Pereira accepted, and what he's not saying, and what he doesn't say anywhere, is that, but with the diagnosis of bipolar, it was understandable that there wouldn't be psychotherapy, because that's the implication from the beginning of 224, that the excuse, if that's the right word, for not getting psychotherapy, the reason for not getting psychotherapy was that the diagnosis of bipolar didn't involve the obtaining of psychotherapy. Whereas nowhere, Dr. Pereira doesn't say, but I didn't but because I've made a diagnosis of bipolar, I didn't think psychotherapy was necessary until later. Nowhere is there an indication that anybody suggests that the reason for not getting psychotherapy was the diagnosis. And that's the jump, the missing link, we say, is that the difference between a diagnosis of bipolar and a diagnosis of PTSD is the only reason, as one gets from 224, that he didn't get psychotherapy. That simply doesn't fit with the judge's other findings, which is that psychotherapy was an essential part of the treatment, whatever the diagnosis.
Where does the judge find that?
Yeah. Where does the judge find that?
Well,
Where does he say that in terms?
well, he doesn't ever say that bipolar wouldn't have involved psychotherapy. The only thing he does say in respect of that is he quotes Dr. McGanty at paragraph 142 for saying if Dr. Pereira had ultimately arrived, this is Dr. McGanty who he doesn't accept, but the only place in which he refers to different treatment for bipolar is 142. If Dr. Pereira had ultimately arrived at a confirmed diagnosis of bipolar, psychotherapy would not have been indicated at all. That's Dr. McGanty who hasn't accepted. But if the patient's innermost thoughts revealed some past experience that was traumatizing him and causing him to be overwhelmed by life stresses, then psychotherapy would be helpful. And that again goes to that's what Dr. Pereira did know, and if that had been part of the handover, it cannot be said that it's the diagnosis of bipolar that prevented him getting psychotherapy. And indeed, as my lady has pointed out, that Nightingale didn't consider that psychotherapy wasn't appropriate because of the diagnosis of bipolar. So it cannot be right that that's the reason he didn't get it.
Well, again, I don't think you've answered my Lord's question. Where do we see the judge's clear statement about therapy?
Well, he accepts Dr. Meehan's evidence that psychotherapy was the cornerstone.
Just remind us where that is in the judgment. Where is it?
125, I think. And that's the benefit of hindsight quote as well.
But although it's said, I'm sorry if I'm repeating it, but it's said with the benefit of hindsight, what is not said is, I didn't need to get psychotherapy, to arrange psychotherapy or to suggest psychotherapy in the handover because bipolar is not helped by psychotherapy. Dr. Pereira never suggests that the reason for not getting psychotherapy was the bipolar.
Well, should we look at one? The ladies landed on 125, which that's where the cornerstone reference comes, isn't it?
Yes. I've
Dr. Meehan also perceived a breach of duty in a failure for Mr. Jones Committee to discuss with him the benefits and role of therapy in his treatment. Therapy was the cornerstone of any treatment plan. The failure by all the defendants to act on his rejection of group therapy and arrange individual therapy was also negligent. Complex case. That's Dr. Meehan perceived a breach of duty. Where do we find that breach of duty found by the judge?
Well, the breach of duty found by the judge is in relation to the handover.
Are you extrapolating or expanding on the breach found by the judge to include the failure to prescribe therapy as the cornerstone for any treatment plan? And
Yes,
is that open to you to do that, if that's what you're seeking to do?
well, it is because that's what was the failure to give a handover must involve the failure to explain what he knows about the patient and what he thinks the treatment plan should be. And in cross-examination, he said he was involved in the treatment plan.
But the judges, I'm coming back to 191. I'm sorry, like a cracked record. That's not what the judge found at 191. The judge didn't find that that Dr. Pereira had had devised a clear treatment plan to include therapy. He did not find that, as is clear from 191.
But that doesn't sit with he didn't give a proper handover, because what is a proper handover if it isn't a treatment plan and the information that he has about the patient?
Well, it obviously is the latter, and you can see what there's guidance as to what the handover should include. Judgment.
It's 181 and 182 is where the judge finds what a proper handover would have contained. The history, the issues, my thoughts, views, ideas, the treatments I've tried.
Yeah.
When you read 181 and 182 together with 191, what the judge has found is an adequate handover says what he's done, what he's found, but does not include a care and treatment plan or what will happen once admitted, because that's a matter for doctor's action. And at the moment, it seems to me you're trying to expand on the judge's finding of negligence to include a finding that a proper handover would have included a treatment plan which would have said you should do individual psychotherapy for this patient. The judge has not found that. I can't see the judge having found that. Indeed, he
Finds the opposite.
deals with that allegation expressly at 186. The core allegations are that Dr. Pereira himself did not interact with Mr. Jones in the way that he should have, but he did not ensure that Mr. Jones received individual therapies. That's that allegation, and he rejects that, as my lord has said, 191. So, the burden of your submissions this morning has been, given what the judge said in 224, the only real difference between what happened and what the judge envisaged in 224 was the diagnosis. It was a bipolar diagnosis rather than a PTSD type diagnosis. And that can't logically make a difference given the evidence. But what you are in effect inviting us to do is add, I think, to the judge's findings of negligence to include the one which he looks at 186 and rejects at 191. And it's not obvious to me that that's open to you on the judge's findings and the grounds of appeal we have.
But what
And the point
Is-
is taken up by Mr. Porter in his skeleton argument.
I'm sorry,
And the point is taken up by Mr. Porter in his skeleton argument.
yes.
Because there is no challenge to 3 specific findings of breach. And the one which, speaking for myself, I can understand you concentrating on is the failure to give an adequate handing.
Yes,
But
indeed.
that's really the confine.
But if an adequate handover included what is set out in paragraph 181, it would have included what Dr. Pereira said in evidence, which is that therapy was an important. If it would have included what he tried, what he knew about the history, which included a history of earlier trauma, and what he knew about psychotherapy, and that he was going to try CBT was what he was going to try. So if one transposes 181 into the handover, one can't then get to the position where the only reason he didn't get treatment was because the diagnosis was just bipolar. Because it would then have followed that the appropriate treatment would have been psychotherapy, and he's not in 224 suggesting that that would have involved him finding any breaches on part of Dr. Bakshi, because that is not relevant to what would have happened if he'd been admitted with the proper details that should have been provided to Dr. Bakshi.
I'm sorry to go back to 191, and it really is a crack record. But in addition to the point that the Lords picked up on, linking that to 186, there's also the seemingly important element of whether or not the patient would participate. And the judge found that Dr. Pereira at that point wasn't in a position to make any assumptions about participation. That would have to go over to Dr. Bakshi. And for that, that's another reason why he found that he could not find Dr. Pereira liable for any admissions in the treatment, because it all went over to Dr. Bakshi. And what, as Milady's pointed out, the very next day there was an assessment.
Dr. Cam, yeah, the
It's
assessment.
an assessment by Dr. Cam.
But what we say is the flaw is that none of that affects the analysis of 224 if the appropriate treatment was psychotherapy. In subparagraph 3 didn't detect a significant disagreement about the appropriate treatment of such a case with psychotherapy. So in this hypothesis, psychological therapy would have been a key part of the treatment plan nearly 4 weeks before he died. So that isn't depending on anybody. That is assuming that that is what would have happened.
Well, but how does that address the point about participation I've just put to you?
Well, it doesn't. It assumes that he would have found it would have happened. And what he says about that is nearly 4 weeks before Mr. Jones died. And if the group therapy programme in the hospital was rejected, individual therapy would have been arranged promptly. He's made a finding that that is what would have happened if psychotherapy had been part of the treatment plan. That if he had he's made a specific finding that he would, if the group therapy had been rejected, which indeed it was, individual therapy would have been arranged promptly. If properly functioning therapeutic and risk management framework had been established, it was likely his condition wouldn't have deteriorated to the point he reached. So he's saying these are the findings he would have made absent the bipolar diagnosis. So, and there's no, the judge has volunteered these as the findings that he would have made. And that's why we say there is a real inconsistency, and that's exactly the inconsistency we pick up with 191 and 192. Why don't the factors in 191 and 192 get reflected in 224? They simply don't. And he's telling the family, if it hadn't been for that diagnosis, I would have found he would have got the psychotherapy. And if he hadn't participated in the groups, which we know he didn't, he would have got the individual, and then he wouldn't have died. And he's apologising to the family for setting it out like that, but he's setting it out very clearly as to what would have happened, only with one thing being different, which is the basis of admission, which he says was bipolar, and that's why I didn't get it. You've only got to tweak that to, there's a differential diagnosis, but I've also know that therapy has been tried, therapy is what's needed. You tweak that at the outset of 224, and everything else follows on the judge's own analysis.
Well, I think we have that point
My
now.
lord,
Right?
yes.
It's obviously a crucial part of your case, and we will certainly consider it. But there are no doubt other points you need to make.
Yes, if I can just add, that point is again made in paragraph 238. I just point that out.
Thank you.
It's in the quantum section,
Yes.
but he says in 238, I would have calculated what the award would have been if I'd found, contrary to my conclusions above, was negligent for Dr. Pereira not to proceed on the basis of a post-traumatic diagnostic formulation. On that hypothesis, the test of causation would be satisfied, because on the balance of probabilities, Mr. Jones' condition would at worst have remained stable, and he would not have experienced the deterioration which was manifested by his self-inflicted death on the 18th.
Thank you. Yeah.
So again,
We
it's
note that.
that one
Yes.
tweak, as it were,
Yeah.
and that's also relevant to the other inconsistency we say, just following through on the ground one inconsistencies, is that on his return, Dr. Pereira, the judge found it was a breach of duty not to start psychotherapy, and yet he also found that Dr. Pereira had not changed his diagnosis from bipolar. So there is an inconsistency. I know the defendants say, well, other things have changed, but that wasn't the basis on which the judge found that there was a breach of duty in not arranging psychotherapy.
But the judge found, as a matter of fact, that by the time Dr. Pereira came back in on the 11th of April, matters had changed. He'd been an inpatient for some weeks, and there had been no improvement in his condition, possibly even deterioration. That was a finding by the judge.
Yes, but it was a finding by the judge following from him not getting psychotherapy from the outset, and that Dr. Pereira should have seen. All it goes to is that the diagnosis of bipolar was not the reason why he didn't need to get psychotherapy. If that is the reason, then it wouldn't have been a breach of duty not to get psychotherapy at that stage, if the judge thinks if he thought the diagnosis of bipolar was the excuse for there not being psychotherapy. That's the inconsistency. Because the suggestion that the judge, we understand, made in 224 was the only reason psychotherapy wasn't appropriate was the diagnosis. And without the diagnosis changing, it becomes a breach of duty not to get psychotherapy.
But at 202, the judge draws a distinction between two situations. He says it was reasonable to see if Mr. Jones would engage with the group programme when he was admitted, but by the time Dr. Pereira saw him again, it was clear that he would not. So the judge is saying it does make a difference when he comes back from holiday, because by that stage we know, and he knew, that group therapy wasn't working, he wasn't being engaged with.
But two
That then leads to his conclusion that he should have arranged individual psychotherapy, which is the conclusion he reaches at 201. But he's clearly rejected at 191 the suggestion that Dr. Pereira should have arranged individual psychotherapy before he went on holiday. And one can see that the two situations are, in the judge's view, different factual situations. Why is the judge wrong about that?
Well, at 203, he is saying Dr. Pereira's evidence, both at the inquest and the trial, was psychotherapy was an important part of the treatment plan. So that it's not confined to if everything else had failed. He's saying it was an important, in these circumstances, when he came back, he would put in train the process of arranging psychotherapy, despite the bipolar still being the diagnosis. So it's difficult to see why the treatment plan, that isn't the finding of the treatment plan, has changed because everything else had been unsuccessful.
When Dr. Pereira says in 203 psychotherapy was an important part of the treatment plan, I don't read that as being an acceptance that individual psychotherapy would from the outset have been part of the treatment plan. Group psychotherapy would have been included in that, is that not right?
Except that we know from 224(4) that if the judges found
Well, yeah,
that
exactly. But
if
group therapy first, and then if rejected, individual therapy.
yeah. So he has found that if psychotherapy was part of the treatment plan, he would have got individual.
Yes,
That's
I
the link to individual from group. Is the judge has found it if he had rejected the group, he would have got an individual without having to find any other breaches. He's just saying that is what would have happened.
I mean, but the hypothesis, I mean, I know we're getting around in circles to some extent, and I'm sure it's my fault, but the hypothesis which he was referring to at 224, which I mean, the conclusion, the contrary conclusion he refers to at 224, is the one that's set out, or finds its root at 119 in the evidence of Dr. Meehan, isn't it? Who doesn't say that any reasonable psychiatrist would have arrived at that interpretation. Isn't that right? So 224, he says, if contrary to my conclusions, any reasonable consultant psychiatrist would have provided the post-traumatic diagnosis as described by Dr. Meehan, who would have done so before Mr. Jones' admission. The conclusion which he is referring to is based on Dr. Meehan's evidence, which was that although that was his interpretation, he wouldn't go so far as to say that no reasonable psychiatrist could have arrived at a different interpretation. I mean, I've got it the wrong way around, but the judge is very clear that's an important piece of evidence. So that's a sort of tipping point of his analysis, isn't it?
But what he doesn't then go on to say is, and therefore psychotherapy wasn't a necessary part of the treatment plan because it wasn't negligent to find bipolar. And in fact, the only references that Dr. Morganti, that he didn't accept, had suggested that if there was a firm diagnosis of bipolar, it might not have been useful, but if the patient's innermost thoughts revealed some past experience that was traumatizing him, then psychotherapy, even with bipolar, would have been the right treatment. So nowhere has the judge found that it's the diagnosis of bipolar that excludes the psychotherapy.
Right. Well, Ms. Gumbel, I think we've had another look at that point now, but I do think we need to move on. I'm just looking at your map.
I've
Are we still on the logical floor? That's the
I
point,
think
isn't it?
that this
That's
is the
point
point we've
ground
been
one, the logical
looking
floor.
at.
Are you coming on now to deal with
Um,
round two and the Hodgson test point? Or have you covered that? No, you haven't, have you? In part.
yes. In terms of what I have set out there are the references where Dr. Pereira accepts ultimately that he was the admitting doctor, and where he says what the treatment would have included psychotherapy.
Yeah.
So I have set the references out there.
Yes.
In your skeleton argument.
I'm sorry, in the
On the map.
map I've put the
Sorry.
references in relation to the
Yeah.
therapy.
We've looked at a lot of those, haven't we? I think, or certainly some.
And what I say in relation to those is that nowhere does the defendant suggest that the one-to-one therapy wasn't appropriate because of the bipolar diagnosis. And there is also the point that the defendant says he thought that had said that he thought the deceased was in any event accessing one-to-one psychotherapy outside the hospital, but when cross-examined about that, accepted that he might have attempted to but hadn't, so he actually thought he was getting psychotherapy, so thought that psychotherapy was part of his treatment. But what is important about what those references and what the defendant's own evidence is about psychotherapy is that nowhere does he suggest, because I'd made a diagnosis of bipolar, I didn't think psychotherapy was the appropriate treatment. And yet that seems to be the only way one can understand the first aspect of 224, is that that is what the judge had found, and that was contrary to everybody's evidence, as I hope I've...
Yes, I think we have, as I said, I think we have your
So
point.
in terms of the Hodgson test, if the judge's analysis at 224 and 225 is that he would have had the basis of the admission led to psychotherapy, and the steps that he set out there happened, then the finding, he makes a specific finding that the chances of success would have been more than 50%, and that would satisfy the Hodgson test. I think that's probably clear, but we've put Hodgson
Tab 9 in the authorities bundle.
in the authorities bundle, and it is the point that the judge himself says, I'm only talking about chances, but he does say that the chance is over 50%. Hodgson is at behind tab 9, and it is the case that established that a chance of less than 50% of past treatment working doesn't entitle the claimant to recover at all, but a chance of over 50, even if it's only 51, entitles the claimant to recover in full. So we say if the court accepts that the court was wrong to find the bipolar diagnosis is what made a difference, and that with a admission with the details that should have been on the handover, psychotherapy would have followed, then on his own analysis, he satisfied the Hodgson test. So if I can then move on to material contribution.
Yes.
And we say this is obviously an alternative ground. And we do criticise the judge's analysis of how the Bailey and Williams material contribution test worked. At paragraph 212, start at 210, but unable to decide whether for any negligence breach Mr. Jones's death was on the balance of probabilities of avoided, should instead consider whether any negligence made a material contribution to his death. And he cites Bailey and Williams, which I will come to briefly in a moment. But in 212, my judgment, this is not the sort of case, and it is possible to decide on the balance of probabilities whether death would have occurred in the absence of breaches of duties that I have found or that the claimants have alleged. So what I understand from that paragraph is that you don't look at material contribution if you could decide on a balance of probabilities one way or the other, whereas we would say you look at material contribution
can't.
because you can't.
Yes. I follow that.
So that so what he said is, in theory, if he could have decided on the balance of probabilities, it's not relevant to look at a material contribution.
Which you would accept.
It is.
You accept that proposition.
Well, for the
But if you can't, your point is, if you can't find what about probabilities, you then have to go on to consider.
Indeed.
And your case is he didn't. Is that right?
Indeed.
Right.
That he didn't because he thought I could have found on the balance of probabilities and I didn't. Therefore, end of story is effectively what he's saying. I don't need to consider material contribution.
Right. Are you going to take us to Bailey?
I am. I'm just going to point out the two areas in which we say that material contribution it could be relevant and which he should have considered it. One night, and where there is another flaw in the analysis, and that's going back to, I'm afraid, the paragraph we've kept looking at 192.
Yeah.
I therefore cannot find Dr. Pereira liable for any omissions in the treatment Mr. Jones received until his return, whilst the lack of handover to Dr. Bakshi may have contributed to any admissions by her. I have not tried the question of whether there were any admissions by her, but there don't have to be admissions by her. There just has to be a contribution to the decline in the underlying condition, which is not an admission by Dr. Batch. There doesn't have to be another negligent cause for material contribution. There can be, as Bailey and Williams illustrate, there can be a material contribution where the other cause is a natural, inevitable one due to the underlying illness, and both Bailey and Williams were sepsis and other underlying.
Yes, but the
conditions.
breach is handover. If the breach is handover,
Yes.
doesn't that tie it to omissions by the person to whom he was handing over?
Not necessarily, if he's right that what the diagnosis is what determines what the hospital do and what the information the hospital have. If on handover, if the handover had been responsible and had included what he identifies as, which is what treatment he's already tried and what treatment and what he's discovered about the underlying traumas that the claimants reported to him, if that then leads to a deterioration in his condition because he doesn't get psychotherapy, it doesn't need to be somebody else's negligence that he doesn't get like psychotherapy. If he's made a contribution to that by not giving the details which would non-negligently have involved improvement there doesn't have to be an admission by someone else for there to be a material contribution.
And that material contribution has to be
More than negligible. So what we say is that ignores the possibility that there can be both negligent and non-negligent causes for there to be a material contribution. And the second respect is in relation to the start of psychotherapy on return on the 10th of April. He's found a breach of duty in not placing a treatment plan with a clear path to individual psychotherapy. And given that Dr. Meehan's description of paragraph 219 of what was needed was to give him hope, in paragraph 219, in cross-examination, Dr. Meehan was asked to confirm taking therapies typically take time to work. 1 or 2 sessions in the final week would not have saved Mr. Jones' life. His answer was, what it might have done is given him hope. And if even 1 or 2 would give him hope, that would be a typical situation in which one can't say on the balance of probabilities it was the cause, but it did make a material contribution because it wasn't started and didn't give him hope, whereas starting the psychotherapy, or even telling him he would start the psychotherapy, if that gives him hope, would make a material contribution to his decline, which undoubtedly happened between his return on the 10th and the deceased's death on the 18th. So that is paragraph 203 to 205 is where he finds that any reasonable consultant would very soon after 11th of April have put in train a process for deciding on an appropriate form of psychotherapy at the hospital, arranging for it to happen. And then at 2:05, I therefore conclude that the care and treatment plan was deficient because it did not contain a clear path to Mr. Jones starting individual psychotherapy. Does not mean, however, that if the appropriate steps had been taken, would have had many, if any, psychotherapy sessions before the 18th of April.
Now,
But-
I have read that first sentence as confining the care and treatment plan to the period on Dr. Pereira's return.
Well, I think at this point, yes,
Yes.
it is, but what I'm addressing that is in relation to material contribution, even at that stage, arranging one or two, whilst it may not have, whilst he's found it hasn't caused the death on a but-for basis, he hasn't gone on and should have gone on to consider, did it make a material contribution to his deterioration thereafter, and there rely on the lack of giving him hope. Then, in relation to how that fits with Bailey and Williams, if I can go to those. We have marked
We go to Bailey first.
please. Is it right that the Bailey decision is to be read in the light of Williams as well, but in both the position that's behind tab 3. The passages we've marked demonstrate page. This is a case in which what the judge found and the Court of Appeal agreed, although there is in Williams they also find the judge could have found on a but-for basis, but nevertheless the findings in the Court of Appeal endorsed the judge's analysis on a material contribution basis, where there was a page 35, the passage we marked at paragraph. The claimant's case is that if she'd been properly treated for the removal of the biliary obstruction with proper post-operative management, probability is she would not have become as ill as she did and would have recovered sooner, with the result that she would not have been so weak that she aspirated, leading to her cardiac arrest and consequent hypoxic brain damage. Put shortly, the case on the facts was there was a lack of care and resuscitation, not ultimately an issue. Proper care would have led to early intervention, preventing her becoming as ill and weak as she became, and it was that weakness which caused or materially contributed to the lack of care that led to her being unable to prevent herself aspirating. So that demonstrates that the contribution can be to the underlying deterioration. That one doesn't have to find an omission by somebody else in order for there to be a material contribution. And the final, I've also marked the analysis at page 37, but I think the summary at page 45, paragraph 44 onwards, are there any cases in the medical negligence context that cast any doubt on applying Wardlaw's case in this context? Certainly in Wilshire's case, applied strictly the but-for test. That's where there were several competing causes and you couldn't say which one it was. Reject the interpretation of McGee's case, but it was not a case of causes cumulatively causing injury, but a case where there were different distinct causes which operated in a different way and might have caused the injury, and where the claimant could not establish which cause either caused or contributed to his injury. It was the inadequacies of medical science that put the claimant in the position of not being able to establish the probability of one cause as against another. And the distinction here is, in my view, one cannot draw a distinction between medical negligence cases and others. Summarise the position in relation to cumulative cause cases. If the evidence demonstrates on a balance of probabilities, the injury would have occurred as a result of the non-tortious cause or causes in any event, the claimant will have failed to establish the tortious cause contributed. And that's Hodgson. If the evidence demonstrated that the but for the contribution of the tortious cause, the injury would probably not have occurred, and that's our primary case, the claimant will obviously have discharged the burden. In a case where medical science cannot establish the probability that but for an act of negligence, the injury would not have happened, but can establish that the contribution of the negligent cause was more than negligible, the but-for test is modified and the claimant will succeed. So we say on that basis, if we can't establish on a but-for basis, we can establish that it would have made a more than negligible difference to have at least started psychotherapy, or on the first point to have given a competent handover. Then we don't have to establish on a but-for basis, and that the judge really didn't consider that because he thought that if he could have established on a but-for basis, he didn't need to even consider that. Then the Williams case, similarly, there is a material contribution, but it is right to say they looked at the Bailey case and concluded, tab 4, the material contribution argument to, again, underlying cause, paragraph 40 on page 63, a claim will fail if the most that can be said is that the claimant's injury is likely to have been caused by one or more of a number. This is the paragraph in Bailey. Such a case, the claimant will not have shown as a matter of probability.
Sorry, which paragraph are you reading
I'm
from?
sorry,
Forgive
I'm
me.
just reading paragraph 40, which really is...
I do apologise. 40.
40 on
40.
page 60.
Thank you. I'm sorry. Thank you.
Is repeating the
Yes.
Bailey. And then on paragraph 42, this is a case where there was underlying infection, but it continued for longer than it should have done. And at paragraph 42, on the trial judge's findings, the process continued for a minimum period of 2 hours 20 minutes longer than it should have done, in the judgment of the board, it's right to infer on the balance of probability that the board's negligence materially contributed to the process and therefore materially contributed to the injury to the heart and lungs. But it couldn't be said that it was the only cause. There was a non-negligent deterioration in any event for the non-negligent period. And then paragraph 47, page 65, they address the finding of Mr. Justice Foskett and say there that he could, on the alternative basis, have found that it was the claimant's underlying weakness. It was really an eggshell skull situation. But nevertheless, that doesn't detract, we would say, from our point that you can have material contribution in circumstances where you cannot find on a but-for basis, but where there is a breach of duty which is significant but not sufficient to prove on a but-for basis, and that's what the judge should have and didn't consider in terms of either the breach on the handover or the breach in getting psychotherapy at the end. And that aspect of the appeal we say is an error of law, because his understanding of the material contribution cases was that you didn't even get to the starting blocks, because you could have found on a different scenario on a but-for test.
The Privy Council's commentary on Bailey
Yes,
is overdue, isn't it?
it is. It's just, and it isn't undermining that there could be material contribution in the
Well,
Bailey circumstances. is it?
It focuses not, am I right, not on the Court of Appeal's judgment in Bailey, but on the judgment at first instance of Mr. Justice Foskett.
My lord, yes, it is suggesting an alternative way in which the judge might have found for the claimant on a but-for basis because of the underlying weakness of the claimant in that case. But the Court of Appeal still found that where you have added to the problem by not treating for a period of time, but it doesn't detract from the fact the Court of Appeal found that if you can't establish on a but-for basis, there is an alternative route, which is the material contribution. And that is an alternative where the same negligent act is not sufficient to be the but-for cause, but is nevertheless a significant contribution.
Well, it's quite difficult to know what the board of the Privy Council thought about the Court of Appeals.
They don't comment on.
What they say in Rule 47 is the board does not share the view of the Court of Appeal that the case involves a departure from the but-for test. So they're certainly not endorsing the analysis of the Court of Appeal that if you can't get there on a but-for test, you can get there by a material contribution. Because they say, well, viewed properly, it was a but-for case.
But they are endorsing the findings in the Bermuda case.
Yes.
So they're not saying you never can, they're saying in that case it wasn't necessarily essential to depart from it.
Yes,
But
I see.
on the findings in the particular case in Williams, they weren't finding on a but-for. That was where there was an hour and 20 minutes extra of deterioration that was inevitable anyway, which is perhaps the nearest scenario to that in this case of he was deteriorating by the 10th of April anyway, but there's further deterioration because of his hopelessness and not getting psychotherapy arranged, and even arranging one or two would have made a contribution, if not proved on a but-for basis that he wouldn't have died on the 18th of April. Would have made a material contribution to stemming the deterioration, because that was the point of it. And why we say that's important in the context of this case is that the judge just wouldn't address it because he wrongly understood, we would say, the import of the material contribution cases to a situation where the but-for test can't be established on the particular facts.
Thank you.
I'm promising to hand over to
Yes.
Mr. Sheldon on the...
Does that cover, that seems to
I
me to
hope
cover
so, and
your
I
point
hope
on material
the
contribution?
Matt will give you the other references in
Yes,
terms of the treatment plan and what
yes.
they really
Well, that's very helpful,
intended to
Ms. Gamble.
demonstrate
Thank you
are
very
the
much.
points.
Thank you very much, Ms. Gamble. Now, Mr. Sheldon, you've
My lord.
been allocated contributory negligence. But for my part, I wouldn't want to stop you developing any point emerged in the course of Ms. Gamble's submissions which you thought would assist your client.
Well, I'm grateful for the opportunity, my lord, and perhaps I can reflect on that.
Yeah.
But start with contributory
Yes.
negligence. And my lords, my lady, as you anticipated, it's a short point, but an important one for reasons which will be obvious to the court. My submission is simply that on the evidence available to the judge on this issue, there was no sufficient evidence to justify a conclusion that Mr. Jones contributed to his death by his own fault. The reason that the judge mistakenly believed that there was sufficient evidence to justify such a conclusion was that he asked himself the wrong question. The question that the judge asked himself was whether at the time of his death, Mr. Jones, quote, knew what he was doing. That is to say, he was aware that he was throwing himself in front of a train. That was a necessary part of the analysis, but it was not sufficient.
Yeah.
The judge needed to go further, and he needed to assess whether the evidence established that Mr. Jones, at the time he took the action which led to his death, had retained sufficient capacity or personal autonomy, to use the core language, to which I'll return, to make a reasoned decision between a negligent... Oh, I'm so sorry.
Yeah, can you start again?
Shall let me start that submission
I was
again.
autonomy, which is a phrase I come across elsewhere, as you'll appreciate, rather flashed in front of my eyes. And do you want to start again, that second question?
I would be.
He
I
needed
would
to
be
go
grateful.
further. Yes.
So he needed to go further and assess whether the evidence established
Yes.
that Mr. Jones, at the time he took the action which led to his death, had retained sufficient capacity
Yes. Or autonomy.
to make a reasoned decision to choose between a negligent and a non-negligent course of action,
Right.
such that he could properly be found at fault for acting in the way that he did. That's my essential submission, my lords, my lady. And I submit that there was no evidence before the judge as to what was going through Mr. James' mind at the time of his death. All the evidence demonstrated was that at that moment, Mr. Jones was in a state of such psychological desperation that, despite his brilliant career, his supportive colleagues, his generous friends, his devoted parents, his loving wife and his young family, he felt compelled to kill himself. That is all the judge knew. And the fact that he appears to have been in control of his limbs at that point, or had been able to hold rational conversations over the course of the preceding few days,
And ours.
and ours, my lady, I accept, told the judge nothing about whether his state of mind at the time of his death was such that he retained sufficient capacity to choose between a negligent and a non-negligent course of action.
Sorry, just that one again, just that last line, please. Mr.
Yes,
Sheldon.
the capacity to choose between a negligent and a non-negligent course of action.
Are you going to come to these words negligent and non-negligent?
I am, my lord.
Because one of the curiosities of the Contributory Negligence Act is it uses the word fault
Yes.
in two different senses. When it's referring to defendant's fault, it means negligence. When it refers to the claimant's fault, it just means not looking after your own interests, which is not usually regarded as negligence. If you
You're quite right, my lord, and the terminology is not entirely apt. I was going to look at that when I come to Lord Bingham in core, if I may, which I'll do very shortly. But before I turn to look briefly at the judge's reasoning, can I just make two short preliminary points of context for what follows? First, the starting point of the analysis in this case, on the assumption grounds 1 to 3 succeed and liability is established against Dr. Pereira, is that were it not for Dr. Pereira's negligence, Mr. Jones would not have been standing on West Hampstead train station platform considering whether to kill himself. And that is a fundamentally different starting point from the conventional contributory negligence scenario, in which the injured person's negligence is a deliberate act or omission on their part, wholly independent of the negligence of the defendant. Obvious examples would include not putting your seatbelt on, driving too fast, running on an icy pavement, riding your bike without lights on, and so on. Conventional contributory negligence analysis. But here, the position is different. The acute psychological crisis and desperation that Mr. Jones was evidently feeling on the 18th of April, which led him to kill himself, was, if we get this far in the argument, the direct result of the negligence of Dr. Pereira to provide him with adequate care. We'll see when we look at core in a moment how that might be important. Secondly, just by way of overarching context, because it's important to put this point down in my submission, When considering the type of evidence that might be sufficient to sustain a finding of contributory fault in this context, it should be noted that no court has ever made a finding of contributory negligence in a self-harm case where it is the defendant's negligence that has led to the deterioration in the deceased's mental health that has led to them killing themselves. In Reeves, to which I'll turn very briefly in a moment, the custody officers breached their duty to the deceased not by causing him to suffer a deterioration in his mental health, but by leaving the wicket open on the cell door. In Core, which was a case where the defendants had caused the psychological injury, no finding of contributory negligence was made. And in PPX, the first instance decision, it was an obiter one paragraph analysis by the learned judge.
Which you're going to say is right.
Which I'm going to say may or may not have been justified on the evidence that she had before her, but I'm going to say for present purposes is a first instance obiter and likely reasoned conclusion, which need not trouble my lords and my lady. But in the ultimate result is no court has ever reduced the extent of a defendant's liability where it has found liability on the grounds that the deceased was at fault for killing themselves.
No, but in Core, several of their lordships said that one could do it.
Yes, and I've been careful, I hope, my lord, not to say so far.
Be very precise in what you've said.
Not to say so far that it is an impossibility or wrong in principle. And I'm directing these submissions at the sort of evidence that one would need in order to reach what I'm going to say is a high threshold.
We're going to find dicta in Core which would reach the contrary.
That's the intention, my lord.
Okay, well, let's see how we go.
By the contrary, my lord, does my lord mean to establish that it might be possible?
Well, both ways, perhaps,
Yes.
in Court.
Yes. Well,
So, let's see where we go.
yes. Can I just, having made those two preliminary points, and before turning to the two cases I want to take, my lords and my lady, to just briefly look at what the judge found, conscious as I am that my lords and my lady have this well in mind.
Yes,
so
and
I'll take this very quickly.
We probably don't need to read it out.
I certainly.
If it's, I don't know.
It's
We can
paragraph
probably read it to
200
ourselves, can't we?
226, my lord, my lady, is the start of the relevant passage of the judgment.
Yeah. Oh, I see. This is the section on the law you're going to refer to, not. This is where the judge deals with the law. Is
Yes,
that what you're going to read out?
my lord. I just want to take you very briefly to remind you of how the judge reasoned this out,
Yeah. Okay.
and then I'm going to go to the two cases.
Okay.
And paragraph 226, he starts just by setting up the point and explaining why it might be relevant. We then have the quotation, as my Lord Justice Nugee rightly identifies, from section 1.1 of the Law Reform Contributory Negligence Act. Although may or may not be significant, it doesn't include the bit that refers to fault at the start of section 1, subsection 1. But then he reviews the authorities, Core and Reeves, and I will go to those in a moment. He refers to PPX, which I've dealt with, and then could I just take you to paragraph 234?
Yeah. This was the bit I thought you probably didn't need to read out. I was conscious.
Yes.
I don't add stress. Should
So
you like us to read it to ourselves?
Would you, my lord? I'm
Which
very grateful.
paragraphs?
234
And 5.
and 5.
Right, we'll go and do that, Mr. Sheldon.
Thank you, my
I
lord.
want to sit down while we do that.
Mr. Sheldon, can you just help me on a matter of fact? If one looks at paragraph 235, we can see their reference to a close friend
Yes.
and being seen in the last days of Mr. Jones's life. It's something you can send in again, but could you tell me when in fact that was?
Yes, my lady. I'm reasonably confident I should be able to do that now.
Well, don't let me
But-
hold you up or
2 o'clock will be fine.
Yes.
Well, certainly at 2.
Yeah,
Thank you.
fine.
Can I just, before turning to the cases, and I'm grateful to my lords and my lady for reading those paragraphs, just take you briefly to 220.
Yeah, lack of evidence.
And could I just invite you to read that paragraph as well?
Yeah.
And just for the purposes of the note, although I've no doubt my lords and my lady will have this anyway, when in paragraph 234, the learned judge referred to the CCTV and Dr. Magdanti's commentary on it.
Yeah.
That's paragraph 110.
Thank you.
So
Thank you.
the essential point that the judge identified, or the question that he posed to himself, was whether, in his judgment, Mr. Jones, quotes, knew what he was doing when he jumped in front of the train. And only if he did not know what he was doing would it be appropriate to absolve him of responsibility for his death altogether and make no finding of contributory negligence. And that is the analysis that is picked up and endorsed by my learned friends, paragraph 46 of their skeleton. Only if the deceased is acting, as they put it, an automaton, can they escape a finding of contributory negligence in these circumstances. I'm going to go to the authorities now, my lord, but can I just make this introductory observation? In my submission, a binary distinction between automatism, whatever that may mean in this context, on the one hand, and knowing what you are doing, on the other, is crude and unhelpful. It ignores what is likely to have been true in this case, as indeed perhaps in many others, which is that the deceased's mental health deteriorates to a point of such acute desperation that they feel compelled to kill themselves. Put colloquially, they see no way out. They think everyone will be better off if they're gone. A person at that level of acute psychological desperation may well have control of their limbs, may well not be sleepwalking or catatonic. They may be able to hold a coherent conversation or write a note. But that doesn't stop the action of killing themselves being a manifestation of their mental illness. Nor is it sufficient to establish that their death is partially their own fault. Now, with that introduction, my lord, my lady, can I turn to the two authorities that are relevant for this? And the first one is Reeves, which you have at paragraph, tab 10 of the bundle. Now, really, the only purpose of taking you to Reeves is to make good the proposition that in my submission it provides no authority for a finding of contributory negligence in a case like ours, for two reasons. The first is the one that I've already touched on, which is that the deceased's suicidal intent in Reeves was completely unrelated to the defendant's negligence. And secondly, the only evidence as to the deceased's state of mind at the time he killed himself, which their lordships, in some cases reluctantly, felt bound by, was an assessment by a prison doctor an hour before that Mr. Reeves was of sound mind. Sorry, it wasn't Mr. Reeves, I forget that it was his partner and he had a different name. The deceased was of sound mind.
Meaning what?
Well, quite, and their lordships said, "What, we're not entirely sure what that means, but it's the only evidence that we have of his state of mind at the time, and so we feel that we're bound by it."
To what extent are we in the area of thinking about mental capacity?
Well, my lord, I wouldn't, for my part, seek to superimpose the statutory framework, the Mental Capacity Act, on the analysis. And I'm, for my part, happy to pick up, when we come to it, the looser formulation in call,
Okay.
which is directed to the extent to which the individual retains the ability to make a reasoned decision. Per Lord Bingham, I'll take you to that in a moment. So, my lord, I don't seek to superimpose the statutory framework, but I do submit that is ultimately the crucial question: what, at the time of the act that causes the death, is the deceased's state of mind, and to what extent do they have capacity, in the colloquial sense, to choose, the ability to choose between two different courses of action.
Right.
But my lord, I hope some of this might become clearer when we look
Okay,
at call.
I'll keep quiet till we get there.
But very briefly on Reeves, just as I say, for the purposes of explaining why it doesn't justify a finding of contributory negligence in our case. The facts are at page the facts are at page 365 of the judgment, top right hand corner, in the speech of Lord Hoffman. It was Mr. Lynch hanged himself in his cell at Kentish Town. He'd made 2 previous attempts at suicide. One had been in the cell at Clerkenwell Magistrates Court 3 months earlier. The second was in a cell at Brent Magistrates Court earlier that same morning. And then down by letter H, when he was brought back to Kentish Town Police Station after the second incident, he was seen by a doctor. She found no other evidence of mental disturbance, but gave instructions that as a suicide risk, he should be frequently observed. And an hour later, policemen looked through the open wicket to see that he was hanging. Now, the judge dismissed the claim. He found that it was a deliberate act by somebody of sound mind and a novus actus. Court of Appeal found for the plaintiff, not novus actus and no contributory negligence. And Lord Hoffman deals with contributory negligence at page 369 of the judgment. Letter D. This brings me to the question of contributory negligence. He quotes section 1.1 of the Act of 1945 in full, including the bits that the judge in our case left out. And then, if I could take you forward to 372, at letter B, considering, in the course of considering different situations. At letter B, he says, having thought about the position of children, this may equally be true in a case of a prisoner of unsound mind who commits suicide. In Kirkham, where a prisoner suffering from clinical depression committed suicide in his cell, the judge decided that no share of responsibility for his death should be attributed to him under the Act of 1945. And then at the bottom, towards the bottom of the page, at letter F, could I simply invite my lords and my lady just to read the conclusion of Lord Hoffman from the
Lord
sentence
Justice
that starts,
Buxton.
I think, that Lord Justice Buxton's reference.
Yes.
And so, my lords, my lady, the essential reasoning, my submission in Reeves, was that their lordships were faced with a case in which, on the one hand, you had a man acting in, as they felt bound to accept, sound mind, on an intention to kill himself that had nothing to do with the defendant's negligence. And on the other hand, the importance of giving effect to the duty of custodial officers to take care of people in their charge. And they balanced those two competing considerations and came up with a 50-50 apportionment. Now, that is not this case, provides no assistance in this case for the two reasons I've identified. But it's important that I take my lords and my lady to it, because when we come to core now, you'll see that the judgment of Lord Newburger in particular, the learned friend relies upon, it is based in large measure on Reeves.
Right.
So can we go to core? And as my lord has already observed, it is, I would respectfully submit, something of a stretch for my learned friend to say that the law is clear and settled on this issue in circumstances where we have 5 judgments saying largely 5 different things.
Yes.
Core is, as my lord and my lady will no doubt know, unlike Reeves, a case where the defendant's negligence did cause the deceased's mental health to deteriorate up to the point they felt compelled to take their own life. Very briefly, the facts, if I may. Mr. Core was a maintenance engineer who worked at the defendant's factory. He was working on a machine that malfunctioned, causing part of it to swing towards him and strike him on the right side of his head. He suffered significant physical injuries, but also significant psychiatric injuries in the form of PTSD, flashbacks, nightmares, and severe depression. About 6 years later, while suffering from an episode of severe depression, he took his own life by jumping off a multi-storey car park, and his widow sued the defendant for damages under the Fatal Accidents Act. Could I just finally, on the facts, invite you to look briefly at Lord Bingham's speech at page 899 of the judgment, letter C. On the 23rd of May 2002, while suffering from an episode of severe depression, Mr. Core committed suicide by jumping from the top of a multi-storey car park in which he had parked his car some hours earlier. A note which he left behind graphically illustrates the depth of desperation to which he had been reduced. Nearly 6 years had passed since the accident. There was no suggestion that Mr. Core was sleepwalking or was catatonic, but he was clearly capable of driving to a multi-storey car park, parking his car and leaving a note. Now, their lordships were all clear that, were all clear in rejecting the submission that Mr. Core's suicide broke the chain of causation. they all agreed with what Lord Bingham says at paragraph 16 of his judgment, which is at 904. They all agreed that Mr. Corr's suicide was not a voluntary, informed decision taken by him as an adult of sound mind. It was held instead that this was the response of a man suffering from a severe depressive illness, which illness impaired his capacity to make reasoned and informed judgments about his future, and was a consequence of the defendant's negligence. And if I could respectfully invite my lords and my lady to highlight anything in particular in that paragraph, could it be reasoned and informed judgment about his future? So contributory negligence is dealt with by Lord Bingham at paragraph 19. But because he refers back to them, can I just flag up his conclusions on unreasonable act and violenti? So at the bottom of 17, page 905, at letter B, in rejecting the unreasonable act defence, Lord Bingham says, once it's accepted as it must be, that the deceased's unreasonable conduct was induced by the breach of duty which the claimant complains, the argument ceases to have any independent validity. And then on violenti at paragraph 18, the last 4 lines, that was not something to which Mr. Corr consented voluntarily and with his eyes open.
I'm sorry, where are you reading from
I'm
now?
so sorry, my lord. It's the last 4 lines of paragraph 18. In fact, it's probably quicker if I just invite
Whole
you to read
paragraph.
the paragraph. Thank you. So those findings having been made on the various defences that had been run to the claim as a whole, well, Bingham turns to contributory negligence. There's then a discussion at 19 to 20 about whether it would be appropriate to make any significant findings about this at all, given that it was likely argued in the House of Lords and no findings had been made about it in the Court of Appeal, or indeed by the judge. So you'll see at paragraph 20, I very much question whether it's appropriate for the House to conduct what is in effect an independent inquiry into a matter on which the courts below have made no findings, and on which, to the extent that it raises any question of law, we've heard no more than cursory argument. I've declined to conduct the inquiry for my part, but if my noble and learned friends are of a different opinion, this is what I would say. Quotes section 1.1, correctly identifies my respectful submission that attention is directed by the Act to the fault of the deceased and to his causal contribution to the damage which ensues. And then concludes at paragraph 22, for reasons already given, I don't think any blame should be attributed to the deceased. Consistent with my rejection of arguments based on novus actus and unreasonable conduct, which we just looked at, I would similarly absolve the deceased from any causal responsibility for his own tragic death and assess contributory negligence at 0%. Now, Lord Walker agrees with Lord Bingham, and
So he agrees that there isn't sufficient to conduct the inquiry. Is that what you mean?
he agrees with what Lord Bingham says if the inquiry is to be conducted.
Okay.
Can I Lord Walker at paragraph 34, my lord. I'm going to go back to Lord Scott. I haven't.
Finish with Lord Scott.
Lord Walker, paragraph 34. I've had the privilege of reading in draft the opinion of my noble and learned friend Bingham. I'm in full agreement with it. I would dismiss this appeal and I'd add a few observations of my own.
So he agrees, therefore, there isn't sufficient to conduct the inquiry.
I think
He
that must,
agrees with paragraph 20. That's,
presumably he
but
agrees.
if he's wrong about that, he agrees with what Lord Bingham says at 21 onwards.
Exactly so, my lord, and we can see that set out, in case there's any doubt about it, in what Lord Walker goes on to say at paragraph, well, first of all, 37.
Yes.
Briefly, explaining why this is a different case to Reeves.
Yeah.
But then, crucially, at 43 and 44.
Do you want us to read that?
Would you mind, my lord, reading 43 and 44?
He refers to autonomy. Relies on what Lord Justice Sedley said.
Yes.
You rely on I'm sorry, the penultimate sentence in that judgment, in particular. The penultimate sentence of 44. All of the marked passage in 44.
All of the bottom of 44,
Yeah,
because in my submission we are in uncannily similar territory here. Now, for the note, and before I go on to deal with Lord Mance and Lord Newberger, Lord Scott took the view that there should be a 20% contributory negligence deduction in this case. That's paragraph 32. He was the only member of the court who would have reduced damages. Lord Mance, whose judgment starts at paragraph 45, agrees at paragraph 47 that there should be no deduction in that case, but at letter G on page 913 says that I prefer to leave open the possibility that such a deduction could be appropriate in circumstances of deliberate suicide committed in a state of depression induced by an accident. And goes on at paragraph 51 on page 914 to explain how he thinks that's an interesting question which might merit exploration in a future case with the assistance of expert evidence. Between letters F and G, concept of impairment is one which could usefully be explored further in expert evidence in another case. Then he describes, on the one hand, a person suffering from depression may be perfectly capable of managing his or her affairs in certain respects, but be caught ineluctably in a downward spiral of depressive thinking with regard to their own worth and future. So I would respectfully agree. On the other hand, there's a conclusion that a person suffering from a depressive illness has no responsibility at all for his or her own suicide and is in effect acting as an automaton may be open to question in law, at least when the person's capacity to make a reasoned and informed judgment is described as impaired rather than limited.
Eliminated.
So, I'm so sorry, eliminated, my lord. And then over the page at the top of 915, it might be right not only to consider more closely with the benefit of expert evidence what is involved in impairment, but also, as Lord Hope suggested in Reeves' case, to identify differing degrees of impairment and responsibility. So, in my respectful submission, Lord Mance is saying nothing more than this is an interesting issue which we might merit consideration in another case. Doesn't take the analysis much further.
Where was that last bit? Does he meant you?
Sorry, my lord, it's top of 915.
It does say that he has considerable sympathy with the view taken by Lord Scott.
He does, my lord.
Yeah.
He does.
When you read as a whole, he's careful to leave it open. He's certainly not in the it's always 9% camp.
No. And then we have Lord
But he
Newberg.
does say it's a matter for evidence,
He does.
expert evidence.
He does. My lords, I'm going to take you to Lord Newberg, and then I'm going to tentatively suggest the small handful of principles that one can extract from all of this.
You do that by 1 o'clock.
I'm confident I can, my lord.
Right, Newberger.
Lord Newberger,
Yes.
paragraph 57. No deduction would be appropriate because the evidence is insufficient, is the essential point he makes in 57.
Yeah.
At 58, he says, I think it would be wrong to record the fact that, not to record the fact that in agreement with the reasoning of Lord Scott and Lord Mance, a defendant such as the employer in this case could, in principle, succeed in an argument for reduction in damages based on contributory negligence. So not closing the door to it as a possibility. At 62, he draws a distinction between cases where the deceased is of sound mind and where the deceased was not of sound mind, but says that a binary approach of that sort doesn't pay sufficient regard to what Lord Hoffman referred to as the complexity of life. And then goes on at 64, 65 and 66 to say, in effect, there is a spectrum. And 66 is perhaps the critical paragraph for present purposes. There will be cases in the middle where the deceased, whilst not entirely of sound mind, can be said to have a degree of control over his emotions and actions and appreciate what he's doing when he kills himself. There will be cases in which a person will have lost a degree of his personal autonomy, but will not by any means have entirely lost. Then refers to Reeves in support of the proposition that ruling out a deduction would be inconsistent with Reeves. And then, finally, if I may, my lords, my lady, over the page onto 919. Four lines down, the mere fact that the deceased's mental state was impaired to some extent by a condition for which the defendant was responsible, and that he would not have killed himself but for that impairment, cannot, in my opinion, without more, justify rejecting the contention that there could have been a degree of fault on his part. So he's rejecting what might be thought to be the absolutist position of Lord Bingham and Lord Walker, that if it's the defendant's fault that you've got a mental illness, then contributory negligence would not be appropriate in principle. Then at 69, having rejected that absolutist position, he says that the question to be addressed is the extent to which the deceased's personal autonomy has been overborne. That will lead to a different answer in different cases. And then tellingly in my submission, he says, in such cases, the question, while a relatively easy one to formulate, I strongly suspect will be a relatively difficult one to answer, at least in many circumstances. And that is important in my lords, my lady, in my submission, in light of what he goes on to remind us in paragraph 70 at letter F, is that it is for the defendant to establish any deduction on the basis of evidence and argument. So, my lords, my lady, can I attempt to draw those threads together into these propositions?
Yeah.
Firstly, if the defendant raises a plea of contributory negligence, then it is for the defendant to prove that allegation on the evidence. Secondly, the question for the court is whether the evidence establishes that the deceased has retained sufficient personal autonomy over their actions, such that they can properly be regarded as being at fault
Sorry, just sufficient personal autonomy
over their actions, my
such
lady.
that
They can properly be regarded as being at fault for their own death. Thirdly, that will require consideration not simply of whether the deceased has control of their physical actions, but whether they are mentally able to exercise an informed choice between acting in the way that leads to their death or not. Fourthly, in a case in which the deceased's mental state has been impaired by the defendant's negligence, the defendant will need to adduce compelling evidence to prove an allegation of contributory negligence on this basis. Now, my lords, my lady, that is a synthesis, and I make no bones about it. That is an attempt at a synthesis between Lord Bingham and Lord Walker saying, in effect, we struggle to see how this could ever be justified, and Lord Neuberger and Lord Mance saying, yes, in principle, but it would be very difficult and you would need expert evidence.
Where does compelling come from in the last proposition?
Well, my lord, as I say,
That's Sheldon, is it?
that's my attempt, my lord, to summarise the essential effect of two of their lordships saying, in effect, I don't see how defendant is ever going to persuade a court of this. And Lord Mance and Lord Neuberger saying, well, they might do, but it's going to take expert evidence, very careful consideration. It's a difficult hurdle to get over, easy question to pose, difficult one to answer. So if you put all that together...
Well, that's what Lord Neuberger meant by saying it's a difficult question to answer. I don't think he meant that the evidence has to be very high. I think he meant it gives the judge a difficult problem to know where on the spectrum between mortal. you should end up.
Well, my Lord, my lady, perhaps I could invite the court to put square brackets around compelling.
You don't
for
need, you
present
don't need
purposes.
compelling to, if we accept propositions 1 to 3, you get home on ground 4, don't you?
Well, I respectfully agree, my lord, and perhaps I was pushing my luck for compelling.
Why don't you substitute sufficient evidence?
I will gratefully adopt that suggestion, my lord. Thank you.
But can I, just before we break, query whether it's an appropriate approach to a decision of the House of Lords where the 5 of them express different views to try and find, to meld together different judgments. Should we not be trying to look for what the majority view was? Anyway, let me leave that with you. Think about it. Because I would have thought that it's quite difficult in this case to find a majority. But you might say, well, Neuberger and Scott certainly thought, sorry, their lordships, Neuberger and Scott, certainly thought that you could, in an appropriate case, find some liability. And Lord Mance, to my mind, was at least halfway inclined towards that.
My lord, I respectfully agree with that, and I did wonder whether this appeal should be put on the basis that in a defendant causing the mental health case, we should be arguing that in principle a contributory negligence finding is never appropriate, based on Lord Bingham and Lord Walker. But I accept, I hope, with some support from my lord, that actually the majority view was you cannot say in principle never.
No.
And so that is why I've sought to formulate the propositions in the way that I have, by saying, but by not putting it in absolute terms, but by seeking to identify what the evidence would have to show in order to reach the sort of finding that the majority in principle was prepared to
Even if we
acknowledge.
ignored what Lord Bingham and Lord Walker said, you would say ground 4 succeeds just on the basis of what Lord Neuberger and Lord Scott said.
I would, my lord, and what I would propose to do in 3 minutes when we come back is just go back to the judge's findings and explain why it doesn't meet that test that I've just sought to articulate.
Thank you very much. It's very, very helpful.
Mr. Sheldon, my Lord Justice Jonathan Baker raised with you whether there are any matters on which you want to follow. We really don't want to encroach on the time that Mr. Porter has to address the court, but it may be something you should consider over the short agenda.
I'm very grateful, my lady. If I do, it will be very short.
Thank you. 2 o'clock.